Our first speaker this morning is Joe Ortego. Joe is former chair of the network and is the chair of Nixon Peabody's Products, Class Action, Industry, and Trade Representation Practice Group. Joe has defended major commercial, environmental, and toxic tort cases for companies from financial institutions to automotive and chemical companies. Joe is a former New York Assistant District Attorney under D.A. Morgenthau. And interestingly, before we started this morning, Joe and I were visiting that in his class in the DA's office was Justice Sotomayor. So he has some good experience with her and great stories kind of humanizing her. And was telling me that she was actually in the bleachers at a Yankees game recently, which I just don't picture a Supreme Court justice in the bleachers of the Yankees game, but I think that speaks well of her. Joe has a list of publications a mile long on ethics, e-discovery, cloud computing, civil procedure, and more. He leads Nixon Peabody's trial team, which is composed of the firm's most successful and experienced trial lawyers. Joe is also a member of the firm's Diversity Action Committee. He is an active pro bono legal service provider, president of the Board of Trustees of Adults and Children with Learning and Developmental Disabilities, director of TIPS National Trial Academy, and much, much more. Leading off with the topic of early case evaluation is Joe Ortego.
Good morning, everyone. As many of my colleagues here today from the network, I pride myself on having trial skills. And I think that's a unique skill because, after all, trial attorneys are specialized in what they do, which are not readily available and in high-end demand. Trial, at times, in my mind, was the preferred means to achieve truth and justice for my clients. My selfish interest with thinking I have these particular skills, and juries sometimes differ, is that I will have job security. Because if I am unique and able to deliver trial skills to people that need them, I will stay employed. And why is that important to me? Because my wife who's in the audience, we have 2 daughters who are very smart, and I am paying 2 tuitions. So I felt I had job security by my skills. So I thought, until I looked around at the economic realities of trial and reviewed some of the court statistics, which shook my unbridled confidence in my abilities to be a trial lawyer and to make a living. The days of scorch and burn litigation are long over, and times are changing. As lawyers, both in-house and outside counsel, we are continuously confronted with clients with limited resources and very growing, strong expectations. In-house counsel, you sit there and you're directed by management, protect the honor of the company. This is a matter of principle. We're going to fight to the end. Do it. And then you team up with outside counsel and you partner to get this done. But the problem with that generally is protect our honor and our principles and do it for $6.75. And that's the dilemma we face. So what does that really mean to all of us? That discovery and that voluminous discovery of every matter is cost prohibitive. You can't try every matter, nor can every prosecuted wrong be vindicated on behalf of your client. So how do we handle these high client expectations and demands and at the same time do it with the limited resources we have? Well, I have a solution for you on what's going to be a dreary Friday afternoon in the rain: early case assessment. By a partnership, by doing early case assessment, partnering in-house and outside counsel, you can do it. And I want to talk a little about that today, and we could talk about how you can do it and how you can give dignity and preserve the principles of your clients and at the same time do it for maybe $675,000 and not $675,000. Let's first look at some of the statistics and see where we're going here. Civil and criminal cases filed in federal court. The graph is illustrative. Okay, litigation is down, filings are down. That's not the case. Litigation matters filed in the federal courts are up. Except for a slight blip in 2007, the filings are up. And we face that. So there are more cases being filed in federal court than there were the year before. And the forecasters, the litigation forecasters in their surveys say that in 2012 and 2013, those numbers will even increase further. So for a long time, I thought that, hey, You know, there must be a slowdown in litigation. No, there isn't. There are more people are more litigious than ever. Well, the story in New York State is not much different for all of us. If you look at New York State civil cases filed, you'll find that there is a continual increase in New York State courts, not a decline. And you know what I want to indicate? I said to myself, let me look at these statistics. So let me look at the statistics. Well, you know, we've become an asbestos capital in New York, like California in a lot of ways. Maybe they're asbestos cases, or maybe they're personal injury cases. No, when you look at the statistics in New York State, there is a burgeoning growth of commercial litigation. Obviously, we all know why, and now we have commercial litigation parts. So if you think that the growth in New York State is just asbestos cases, it is not. It is a growth in commercial litigation in New York. And New York, by creating these commercial divisions, has tried to make it suitable and a good market for people to bring their cases. And it's almost an industry in of itself. What else have we learned? I'll tell you what else we've learned. Filings are on the rise, and you look at all the surveys, the litigation costs, the average cost per any case filed is growing. And what's also interesting is the lifespan of all these cases. And what I mean by the lifespan is from filing to disposition, that is growing. So you've got multiple things happening here. Filing's up, the cost per case are going up, and the lifespan is growing, and guess what? You have less resources to deal with all of this. So you've got to make some changes, and there's no choice about that. Now, what should you do? I mean, these are the statistical economic realities and have in effect mandated us to make some changes. And it does not matter whether you have one case in your litigation portfolio or a whole group of cases. Early case assessment gives you the answers that you need. Now, if you think that, okay, I don't need to do early case assessment, I'll rely on preparing my few cases to trial, let's look at some of the statistics. Not every case will go to trial. Well, not every case. Probably 98 out of 100 or 99 out of 100 cases never reach a trial. And you know, I was thinking about this, it must be alternative dispute resolution. No, 2/3 of the cases are resolved before discovery is complete, 6% on motion, 22% on settlement and ADR, and the rest, I just don't know. And it's interesting. So if you think you're going to go to trial on your particular matter, the odds are not with you. And the problem you have is, if you want to be in that situation, well, you'll say, this will never go to trial, and then before you know it, you're picking a jury in New York Supreme in the commercial part. Not a comfortable feeling. So what do you need to do? You need to partner with in-house and outside counsel, need to partner. And you know what you need to do? You need to evaluate and you need to think. And you need to make those things now. You need to avoid costly discovery. 75% of litigation spent is on voluminous discovery. You know, one of the problems with us as lawyers is you need to take control of your cases. You need to determine your own fate. You've got to look at the cases early on and decide what you want to do. You don't want to wait for the case to pick you, and you end up in Supreme Court picking a jury and then deciding what you want to do with the case. And if you look at your adversaries, they're shrewd enough to pick the cases. If they have multiple cases with you, they're picking the case that they want to try, and it's not the one you want. And you need to design a path and plan for resolution for every case early on, and that's what early case assessment is. You just can't react, and the reaction is, okay, case is in, let me look at it, it's the answer, I'll answer it. Hey, Mr. Smith defrauded us, he did a terrible thing, file the complaint, put the usual causes of action in, and we'll figure it out later, because Mr. Smith, of course, will capitulate and write us a check shortly after the complaint is filed. It doesn't work. You need to do that. You've got to decide what to do, and good lawyers need to have the courage to make qualitative decisions earlier. Hey, I'm outside counsel. I go in-house. I meet the in-house lawyer. Hey, our CEO is really upset. Our CEO thinks we got screwed, and we're going to chase that guy. Well, so when you go in there and tell that CEO what you're going to do. So the outside counsel is very excited about the opportunity to get a big fat case. They come in, we will crucify them for them, those SOBs. They're no good. We're going to get them, and we're going to get them good for you. You start flaming the fires. But is that what we're supposed to do as a lawyer? And the in-house counsel lawyer sometimes doesn't have the courage to tell the CEO, hey, this case isn't so great for us. This is not the right thing to do. So let's rely on the outside counsel to tell them the truth. Hey, that doesn't work sometimes too, because we don't have courage either. So I guess we have to have courage early on and soon enough to make some decisions here. There's been a lot of talk these days. We have the solution to the problem. ADR. Let's do alternative dispute resolution. That resolves all our problems. Well, ADR is not a substitute for early case assessment. Early case assessment defines the goal. And you need to define the goal of what you want to do before you go into arbitration or mediation. You can't have a successful ADR without establishing a goal from the start. Lawyers must know the end goal before they choose ADR. How many of you have gone to mediation, and you've gone to mediation not with a particular goal, and you walk out of there, how did this happen? I thought I was going to pay X on this, or I thought I was going to receive Y on this, and the time you leave, you have no idea what happened to you. You just got ratcheted up a little by a little by a little, and that's because you didn't have a goal. And mediation isn't a search for the truth. I'm a mediator in the Eastern and Southern District. My goal is to get people to the middle. And I really don't care what's right or wrong in a lot of ways, except to use it to leverage to get you to the middle. And arbitration, people think, is the solution. But arbitration is just a method of getting to where you need to go. And if you think arbitration is cheaper than litigation, I say not. You look at the statistics with regard to arbitration, you do depositions in arbitration. You do e-discovery in arbitration. You have depositions now. You have motion practice. And I did look statistically. I had done a study, and I had called at the time when Judith Kay was our chief judge, and I got a call from the chief judge. I said, "Here, you're doing a speech on ADR. Let me give you some statistics." And when I looked at the statistics that they had, and I looked at the statistics from the different arbitration organizations, the time from filing to the time of resolution was longer for a lot of the arbitration cases than it was in court. So there's nothing wrong with arbitration. Mediation is great, but you have to have a goal. And arbitration, alternative dispute resolution, doesn't just define the goal. So what do? What is early case assessment? Early case assessment is an expedited process for gathering and assessing information, largely through informal discovery and making judgments about the likelihood outcome of the case. Assessing a case at its early stage provides tremendous benefits to the clients, but not what the lawyers like to do. We don't like to make early decisions. We fear failure. Well, if I tell them I think they're going to prevail by looking at this, what happens if I'm wrong? Let me hedge my bets here. Or we look at things, if you start a new relationship with a client, it's hard to tell them, hey, this is not going to work out the way you want to work out. What about this? What about that? It's hard. You need to do it early, and you have to have the courage. Now, how do you do early case assessment? Today there are these complex matters. There are formulas, there's different procedures that you can use, there's algorithms, and there's software you can buy. All of it is very good. But sometimes the old-fashioned way of just sitting down there with a piece of paper and doing the pros and cons to what I call the three-legged stool is the way to do it. You know what the problem with some of these formulas and programs are? We don't think. So we plug the numbers into the program, they give us the answer, and then we have the answer. That doesn't work unless you're going to think as well and make evaluations. The old-fashioned way, there is no program for you to put numbers in. You just simply look at it and use your subjective judgment. And who you need to do this with is very simple. You need an experienced trial attorney as part of your team. You can't do it without in-house counsel. You need outside counsel, and you don't need a litigator. You need a trial attorney. Because when you start thinking about balancing these things, don't you need someone with experience to tell you what the odds are and how are you going to prevail? It's like someone coming in telling me, oh, I've got great legal defenses. I got this widow with 6 children, and there's no basis to bring an action against the company, and we'll get out on summary judgment. And I say to them, no, you won't. The jury will hear all the legal defenses, and they'll filter them out, and they'll turn money back to the widow. They're not going to ignore the law. They're going to turn money to the widow because she's got 6 kids. That you get through experience. And I mentioned this when you pick a trial lawyer. You don't pick the trial lawyer with a 100-0 record to help you make your decisions. You pick somebody who lost. And anybody who tells you they tried a case and never lost hasn't tried many cases and haven't been trying the tough ones. You lose. I remember and I have learned from every case that I have lost. I still get haunted from 1987 that the decisions I made were mistaken in Beaumont, Texas. It comes back. It's a nightmare. And that's what I remember. I can't tell you my victories because they're long gone. Because when I go to the client and I say, this is it, we won our case, isn't it great? Why did it cost so much? Okay, the three-legged stool consists of value, the cost and outcome of all the three critical answers to determine. And then it also, when you talk about value, cost, and outcome, think a little about this. Right now with these formulas, and I took a look at some of these formulas, e-discovery, we'll briefly talk about that. You get scared about e-discovery. Well, so do I. It's too cost prohibitive. You can't do it. You've got to move on. You got to use your subjective evaluation. Some cases, there's no e-discovery now. Depending on who your adversary is, there's ways to limit it. Okay, value. You got to look at the value. Let's take a look at that. What do you want to consider in value? You want to consider exposure. If I settle the case, what happens? Do I get a flood of new cases? Do I look weak? Is it an important case to me? These are subjective things. If I'm a principal and I have an IP case, I've got to defend my intellectual property. That's a lot different than if I settle a frivolous case. Value also measures the risks involved in pursuing trial. Hey, if you haven't lost a trial, you don't know how bad it gets. It's like a piece of fruit that you put in your bag and it rots and the smell gets worse and worse. You go and tell the client, hey, by the way, we lost the case. No problem. Then they start looking at the ramifications. Hey, what about collateral estoppel? What about publicity? Hey, what about the internal disruption you just created in my company? Hey, sales. If you lose an IP matter and you lose your ability to have license for something, you're in deep trouble. So you got to think about what you're doing, and that's part of value. It's not just how much you're going to lose, it's value. The key is to balance this thing, is not what the client might pay, and it's not, and you also want peace on your financial statement. You want peace at your company. That is a value that you've got to consider. It's just not about paying or getting money. Outcome is determining the likelihood of the merits. There's an attorney here called Fitzpatrick. He has an Irish brogue. I don't like the Irish brogue. I'll give you a Spanish accent. But he says, when a lawyer says to you, what's the chances of winning this case? 50-50. If someone tells you 50-50, they haven't looked at your case. If someone tells me, Joe Ortego, you have a chance of playing for the Yankees in center field in Toronto tonight and says it's 50-50, I know. And that's how you should think about it. When you see me in center field tonight, is the chance when a lawyer tells you 50-50, that's a good evaluation. And Fitz, I stole that from you, and you're not here, so I don't care. Do this and gain an understanding of the facts. You got to learn your facts. And you've got to learn what's going on here. And you got to look at the file. I mean, we as lawyers, okay, the case comes in, send me the file, and the file sits there. In-house counsel collects all the information, and it sits there. We never look at it. We'll worry about it at the pretrial conference. You got to be thinking about this stuff. Cost, how much is it going to cost? The frivolous claims, what do I do? What are the general costs? What are the specific costs? And you know what? The discovery costs are outrageous. How many times I've gone to a lawyer and I see this beautiful discovery I get. And it's beautiful. Notices to omit, document requests, interrogatories. And I turned to the lawyer and I said, hey, this is really great. What the hell am I going to do with this stuff when I get it, when we try the case? I don't know, but everybody asks for it. You got to limit the discovery. You got to decide what you want and what you really need. When I was in the DA's office, there was no such thing as discovery. We just tried cases. Electronic discovery, it's a process of identifying and collecting information. Hey, I will tell you this, that e-discovery costs can be prohibitive. The materials are in your slides, but it's not the end of the world. You can manage e-discovery, and that in and of itself is not enough to settle a case. Hey, when should you do early case discovery? It gets late early, according to Yogi Berra and my Yankee team, and he's right. It gets late early. You got to do this when the case comes in. And you know what? Your visceral reaction to this is what normally happens and normally works. Delivering ECA to clients, you got to be a leader. You need a leader with a proven track record. You got to create a team initially, and you've got to deliver the information to the client. Hey, you got to interview witnesses, and conduct a legal investigation. You know, the law matters, by the way. So we all say, hey, we got a great case, we were treated unfairly, but you go look at the jury instructions, you're not going to win. You got to look at the jury instructions. You got to look at the law. Conduct a factual investigation. I put that in there because sometimes I say, hey, if you have witnesses and they don't like them, you meet the person for the first time and you say, ooh, I want to take a shower. You think that's going to change? You've got to look at that. That's never going to change. And guess what? Your visceral reaction is 99% of the time correct. You got factors for that, informal discovery, information from the client. You need the in-house counsel. In-house counsel's got to tell you what's going on in the company. Without in-house counsel, you're not going to be successful at trial. Assessing the risks. After you get your little piece of paper, you plug all the factors in and you decide what to do. Voodoo, yes, but not as much voodoo as some of the formulas. And you do a cost-benefit analysis. You decide what you want to do here and what you want to get done. Okay, conclusion. Case filings are up. Litigation costs are up. The percentage of cases going to verdict are low. You don't want to be the wrong case. Procrastination is not the answer. Courage is the answer. Get there and look at it and decide what you want to do. And for those of you that are concerned about my job security, I am going to pay Alexandra and Juliana's tuition with my wife as well. Why? Because my skills as a trial attorney are still needed in early case assessment. I wish you luck and thank you.